Thank you, Commissioner Fielder's here.
All right. Thank you, Commissioner Fielder, for letting us know there's an issue. Good morning. Time is now 9:33 a.m. Today's date is November 22nd, 2022. I call this meeting of the Montana Public Service Commission to order. Would my colleagues join me in reciting the Pledge of Allegiance? All right, thank you, colleagues. Commissioners O'Donnell, Pinocci, Vice President Johnson, and myself are in the Bollinger Room. Commissioner Fielder is participating remotely. Therefore, we do have quorum. This will be the time and place for public comment. Are there any public commenters in the room? Seeing none, are there any commenters online? Seeing none. All right, there are no changes to the agenda this morning, so we'll move right into action items. Action item number 1 is approval of the commission minutes for the week of October 31st, 2022. Is there a motion? Is there a second? Any changes to the minutes as drafted for the week of October 31st, 2022? Seeing none, all those in favor of the motion by Commissioner O'Donnell to approve the commission minutes for the week of October 31st, 2022, signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Minutes are adopted. Action item number 2 is approval of out-of-state travel. Mr. Rosequist.
Good morning, Mr. President and Commissioners. Staff requests approval for Dan Sherwood to travel to Coeur d'Alene, Idaho, November 28th through December 1st, and Orlando, Florida, December 5th through the 9th, to complete on-the-job training sessions with Federal Railroad Administration inspectors as part of the FRA certification process for motive power and equipment inspectors. The FRA organized and scheduled these 2 on-the-job training sessions to facilitate Dan's MP&E certification, which requires the supervised completion of multiple inspections of both freight and passenger locomotives and cars pursuant to standards and requirements of Title 49 of the Code of Federal Regulations. The two on-the-job training sessions will focus on the inspection process for air brake tests and related safety systems. During the Coeur d'Alene trip, Dan will work under the supervision of an FRA specialist to complete the requirements for freight train inspections. And during the Orlando trip, Dan will work with a supervisor in the FRA's passenger rail section to complete the requirements for passenger trains. The expected cost of the Coeur d'Alene trip is approximately $600, and the expected cost of the Orlando trip is approximately $1,500. The cost will be reimbursed through the Railroad Safety Federal Grant. Staff recommends approval, Mr. Chairman, Mr. President.
Thank you, Mr. Rosequist. Is there a motion? All right, Commissioner Panochi has moved to approve travel. Is there a second? I'll second. Discussion. Discussion, questions? Seeing none, all those in favor of Commissioner Panochi's motion to approve staff travel for Mr. Sherwood signify by saying aye.
Aye.
All those opposed signify by saying no. Motion is approved. All right. Thank you, Mr. Rosequist. All right, that concludes our action items. We'll now move into our work session. Work session item number 1 is docket 2022.07.078 Northwestern Energy. This is Northwestern Energy's general rate case. We're here to consider 350 Montana's request for leave to conduct a deposition. Mr. Hamilton.
Thank you, Mr. President and Commissioners. When the commission last met, it directed the parties in this docket to submit additional briefing on the application of Rule 26B, which is a standard that governs the course of, the scope of discovery, and specifically applying that standard to 350 Montana's alternative request for leave to conduct a deposition. You'll recall that this particular issue began with a hearing examiner's order that denied 350 Montana's attempted deposition of one of Northwestern's witnesses, Cindy Fang. That hearing examiner's order was then appealed to this commission through exceptions filed by 350 Montana. So in addition to exceptions to the hearing examiner's order, you also have before you, as part of that exceptions request from 350 Montana, an alternative request for leave to conduct a deposition. We now, I believe, have sufficient briefing to answer 2 questions. First, did the hearing examiner erroneously conclude that the commission's discovery rule requires 350 Montana to seek leave before attempting to take a deposition? And 2, if the hearings examiner's order is not in error, should the commission grant 350 Montana's alternative request for leave to conduct the deposition? In your materials for today, you have briefing from the parties on the most recent question of the application of the 26B standard. But with the commission's indulgence, I'll begin by taking a step back and reviewing some of the legal and procedural history of this particular issue. Under the Montana Administrative Procedure Act, the commission, like all agencies, has the authority to create its own rules for discovery prior to a contested case proceeding. That statutory authority is in Montana Code Annotated, Title II, Chapter 4, Section 602. Now, the commission has in fact adopted a discovery rule that applies generally to all commission contested cases. That rule can be found at the Montana Administrative Rule 38.2.3301. Now, that rule that the commission has adopted states that data requests are the primary method of investigation in commission proceedings, but it does allow other methods of discovery with leave of the commission. Relevant here, there's also a statute on point, and that statute is Title 69, Chapter 3, Section 328. It discusses the use of depositions in commission proceedings, and in its entirety, that statute says that the commission or any party to any proceeding before it may cause the deposition of witnesses to be taken in the manner prescribed by law for like depositions in civil actions. Now, this statute was first enacted in 1913, and it has not been revised since its enactment. But the nature of civil actions has changed since 1913. In fact, in 1962, the Montana civil system took a big step forward by adopting the Montana Rules of Civil Procedure. which were themselves modeled after the federal rules of civil procedure. So while the rules of civil procedure did not exist in Montana in 1913, 350 Montana's exceptions to the hearing examiner's order still argue that Montana Rule of Civil Procedure 30, which governs depositions in a civil case, should control in commission proceedings. Now, Rule 30 does provide a liberal standard for discovery. Rule 30A1 allows party to depose any persons, including a party, without leave of court, except in the circumstances provided in Rule 30A2. 30A2, in turn, establishes limits on depositions, including, for example, a cap on 10 depositions that a party can take before leave of court is required to conduct additional depositions. While the rules of civil procedure generally do not apply in commission proceedings, they can be persuasive authority, or they can be adopted expressly by the commission as an element of our procedural rules. So, for example, the commission has not adopted Rule 30 governing depositions. Nevertheless, it is persuasive authority for the commission to consider when evaluating deposition issues. The commission has, however, adopted Rule 26B. And Rule 26B of the Montana Rules of Civil Procedure, as I mentioned at the front end, establishes the scope of discovery. Under Rule 26B, a court can limit, and in fact must limit, the scope of discovery if it finds that A, the discovery sought is unreasonably cumulative or duplicative, or can be obtained from some other source that is more convenient, less burdensome, or less expensive. B, the party seeking discovery has had ample opportunity to obtain the information by discovery in the action. Or C, the burden or expense of the proposed discovery outweighs its likely benefit, considering the needs of the case, the amount in controversy, the party's resources, the importance of the issues at stake in the action, and the importance of discovery in resolving these issues. With this background in mind, I'll move now to the staff recommendation. First, staff recommends affirming the hearing examiner's order. 350 Montana argues that Rule 26B does not apply. However, the plain language of that rule does allow courts in a civil action to limit the scope of discovery, including the number of depositions that a party can take before leave of court is required. It would be unreasonable, in staff's opinion, to interpret that statute in a way that deprives the commission of the authority that every court has to control the scope of discovery in its own proceedings. Now, through its discovery rule, the commission's discovery rule, the commission has effectively reduced the number of depositions that can be taken without leave from 10 down to 0. But that does not mean that depositions cannot be taken. First, parties can stipulate to a deposition, as was the case in the recent L&L docket, where L&L and Republic both stipulated to conduct a certain number of depositions, and it never came before the commission. Or if the parties cannot stipulate, a party can always request leave from the commission to conduct a deposition, which is now the position that the commission is in. If the commission agrees with staff that the discovery rule the commission has adopted is still valid, does not conflict with the statute, then we would need to move on to evaluating that request from 350 Montana. Now, when the commission does receive a request, staff recommends evaluating that request under the Rule 26B standard, in part because it is a rule that the commission has already expressly adopted as part of its discovery rule, and in part because it is a very useful standard in evaluating the relative burden and expense of discovery. So because of the ways that traditional civil actions differ from commission proceedings, applying the 26B standard to the commission proceedings can be different. So we have very short statutory deadlines here in front of the commission. Our rules favor pre-filed testimony, which is rather unlike every civil action that you would see. So you have the advantage of being able to review the entirety of a witness's direct testimony before the hearing commences. And there are actually very few restrictions on the form and quantity of data requests. Unlike civil procedure, there are a limited number of interrogatories of written discovery questions that a party can ask. In commission proceedings, as Northwestern will attest in this very case, the volume of data requests can be substantial, and that makes us different from normal civil actions. And all of those differences may make it easier for a party that is resisting a deposition to establish that 26B, that standard in 26B, should weigh against allowing a deposition. That said, staff still believes it is important to apply that 26B standard to requests like the one that you have before you from 350 Montana. Now, Northwestern's briefing did discuss the ways in which it believes a deposition in this case will overburden the proceedings, particularly in light of the other discovery tools available to 350 Montana that until yesterday, 350 Montana had not yet used. That, again, is data requests as the primary method of investigation. While staff appreciates Northwestern's concerns, the reliability rider that this deposition would focus on is a new and substantial element of Northwestern's rate case. While other jurisdictions may have experience in dealing with this sort of mechanism, the Montana Commission does not. We have no frame of reference, no prior cases to look back on to try to evaluate and understand this request for a reliability rider. While a deposition would impose a certain burden on Northwestern and its witness, staff does believe at this point that the facts and circumstances of this case show that a deposition would be an efficient and effective way of gathering more information about, in particular, this reliability rider, but in general, the entire scope of the testimony provided by Northwestern's witness. It's also worth noting, as Northwestern pointed out in its briefing, this particular witness has already stood up in front of the parties at a number of technical conferences to answer questions about this very issue. While Northwestern points to that as a reason why there were other methods of gathering information, from staff's perspective, it's also a good example of why this would not impose a substantial burden on Northwestern Energy. The witness is already well prepared and willing to answer questions from the parties about this very issue. So turning that from a technical conference sort of setting into a deposition setting should not require substantially more preparation of the witness or a substantial burden on Northwestern's resources. Given the importance of this issue, the uniqueness of the request from Northwestern in this rate case, and the importance of having a timely back and forth between witness and counsel to better understand the issue, staff does recommend granting 350 Montana's alternative request for leave to conduct a deposition. Now, yesterday was the deadline for written discovery to Northwestern in this case, and we are fast approaching the deadline for interveners to submit their initial direct testimony. If the commission agrees to let 350 Montana conduct a deposition in this case, it may be necessary to create some staggered deadlines in the procedural schedule to allow follow-up written discovery based on new information revealed in the deposition, or late filed intervener testimony to address material that was revealed in that deposition. With the commission's indulgence, I believe staff has already been delegated authority to make modifications to a procedural schedule. I just raise it to point out to you all that we will exercise that authority if it appears necessary in order to allow interveners to respond to information in this deposition. Again, if the commission decides to allow the deposition to proceed. I think I beat my own record here for how long I've talked at the beginning of a work session. So I'll stop at this point, but I'd be happy to answer any questions the commissioners may.
Thank you, Mr. Hamilton. I am going to call on Vice President Johnson to make a motion.
Thank you, Mr. President. I would move to affirm the hearing examiner's order to grant leave to 350 Montana to depose Northwestern's witness Cindy Fang. And Mr. President, if the motion receives a second, I'd ask to be recognized for opening remarks.
Second.
Commissioner O'Donnell has seconded. Vice President Johnson.
Mr. President.
Excuse me, in your motion, did it also include the first part to affirm the hearing examiner's decision? I believe it was a two-part motion. I just didn't hear that, if you said that.
To affirm the hearing examiner's
Okay.
order.
I just didn't hear it. I apologize. Yeah.
Vice President Johnson.
Thank you, Mr. President. I have been and remain very protective of this commission's authority to define and control its proceedings within the scope of legislation and rule. I agree completely with staff that it would be illogical to interpret the statute in a way that deprives the commission of the authority to limit the number of depositions a party can take before requesting leave. The Rule of Civil Procedure allows courts to modify the limits provided in Rule 30, and the commission must have the same authority to manage discovery in its dockets. Secondly, I believe the commission needs to retain the discretion to make decisions on a case-by-case basis as contemplated by the administrative rule. History shows that most commission dockets generally do not require discovery through deposition. This is largely due to unique features of the commission's proceedings. Parties can review witnesses' direct testimony in its entirety as soon as the case begins. And as a general rule, there are no limits to the number of data requests a party can submit. However, there may be cases where a deposition is an appropriate and efficient method for gathering information. Applying the factors provided in Rule 26B to the facts and circumstances of this case, I am persuaded that 350 Montana should be permitted to take the deposition of Northwestern's witness. Northwestern has proposed a reliability rider that is in fact a new mechanism in Montana. And we in fact do not have the experience to firsthand to evaluate that mechanism. Allowing a deposition will be an efficient means of gathering more information about the mechanism. And while I appreciate Northwestern's willingness to host technical conferences with the parties to help better understand the mechanism, there unfortunately is no part of those technical conferences included in the record for us to evaluate. Since Northwestern's witness is already prepared to stand up in front of parties and answer those questions in technical conferences, it should not take much preparation for her to answer the same questions in a deposition. It is my hope that depositions remain rare in commission proceedings. I would encourage the parties to use data requests as the primary method of investigation in commission proceedings. And if the motion passes, Mr. President, I also believe it would be appropriate for staff to set reasonable extended deadlines for any written discovery based on information revealed in the deposition, and if needed, late intervener testimony. And as been pointed out, since we have already delegated authority to staff to set procedural schedules, I don't think that needs to be included as part of the direction of the motion. Mr. President, thank you.
Thank you, Mr. Vice President. Commissioner O'Donnell.
Yes, this is the longest explanation of the legal basis of a decision, not just yourself, Mr. Hamilton, but I think that I've ever heard. And certainly this would preclude anyone, whether they disagree in whole or in part with what this commission might do, to say that it wasn't thoroughly examined, that it was capricious, based upon predetermined outcomes or biases on the commission. I appreciate greatly the detailed thought that has gone into this, and thank you very much, Mr. Chairman.
Thank you, Commissioner O'Donnell. Commissioner Fielder.
Thank you, Mr. President. Just a question for Mr. Hamilton, and that would be regarding the extension of procedural deadlines. Mr. Hamilton, do you anticipate that extending those deadlines would impact the end date for the procedures in this matter? Would we need to extend the entire matter?
Mr. President, Commissioner Fielder, it's a great question. At this stage, I do not anticipate that it would require a movement of the hearing date, for example, or the material deadlines that we're trying to meet in order to meet that statutory 9-month timeline to process this case. We are still at a relatively early stage of the proceeding, even though it has been going on for some months now. So I do believe we can absorb some reasonable staggered deadlines as part of our existing procedural schedule.
Thank you. That I think would resolve some of the concern I have with this. I appreciate the explanation given, and I am going to support the Vice Chair's motion in this matter. Thank you.
Thank you, Commissioner Fielder. Additional discussion? Seeing none, All those in favor of the vice president's motion signify by saying aye.
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 All those opposed signify by saying no. Motion carries unanimously. Thank you, Mr. Hamilton. All right, let's move to work session item number 2. This is docket 2022.07.078 Northwestern Energy. It's Northwestern Energy's general rate case. We're here to consider the federal executive agency's motion for Pro Hoc Vice appearance. Mr. Hamilton.
Thank you again, Mr. President. I'll be much quicker on this one, Commissioners. Federal executive agencies have 2 out-of-state counsel. They are licensed and admitted in their jurisdictions in which they live and practice, but they're not admitted in Montana. By rule, before they can make an appearance before the commission and represent a party, they have to be admitted Pro Hoc Vice. And so at this point, they've met all the requirements. Commission staff does recommend granting that motion.
Thank you, Mr. Hamilton. I will move to have the commission issue a notice of commission action granting appearance Pro Hoc Vice for Captain Marcus Duffy and Major Holly L. Buchanan. Is there a second? Seconded by Commissioner O'Donnell. Discussion? Seeing none, all those in favor of my motion to grant appearance Pro Hoc Vice signify by saying aye. Aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. All right, let's move to work session item number 3. This is docket 2021.04.053 commission initiated. This is the intervention rulemaking. We're here to consider issuing a notice of agency decision terminating the first round of formal rulemaking on the commission's intervention rules, which was MAR 38-2-255. And in the alternative, to consider beginning a second round of formal rulemaking on the commission's intervention rules. Mr. Hamilton.
Thank you again, Mr. President. 2 steps involved in this process for at least the staff's recommendation this morning. The first concerns the notice of decision on proposed rule actions. There's a draft of that included in your meeting materials. It's a very short document. What that document would do is end the previously noticed intervention rulemaking without adopting the rules. As you'll recall, there were a number of administrative efficiencies and improvements that the commission had intended to make as part of that initial rulemaking. Unfortunately, we did receive a lot of opposition to the initially noticed intervention rules based on a belief of some commenters that the rule was intended to somehow limit public participation in commission proceedings. Certainly, I don't believe that that is at all the intention of the commission's rule. Nevertheless, we understand, at least as staff, and appreciate the concerns of folks who commented in opposition to that rule. And so staff's recommendation this morning is to end that prior rulemaking and begin a new set of rulemaking. The notice of agency decision would end the old rulemaking, put an end to that particular formal proceeding. And then also included in your meeting materials is the new draft of proposed rules that would be the basis of a new comment period and eventually a new public hearing on our intervention rules. The new proposed rules incorporate a lot more language from Oregon State's rule on public participation and intervention in their commission, utility regulatory commissions, proceedings. And by incorporating a lot more of what other states have used into our rule, we believe that we can address some of the concerns that somehow this language would be misused or abused in order to limit public participation, which again, it bears repeating, is not at all the intention, I believe, of staff in proposing this revised rule, or certainly of the commission in adopting a revised rule. Notably, there have been some changes in one of the most contentious elements of the rule, which was the last subsection of our previously proposed rule. Now you can find it in your meeting materials as item number 9 of the new proposed intervention rule, which addresses the commission's authority to limit the scope of an intervener's participation in proceedings when it's necessary for one of the reasons that's specified in the rule. So unreasonable delay, unreasonable duplication of, when necessary to avoid delay, unreasonable duplication of positions, prejudice to the other parties, or some other finding of good cause. That particular contentious portion of our rule has been revised to include a requirement of notice and a reasonable opportunity to be heard. And what that means is that before the commission does take action to limit the scope of any intervener's participation in the proceeding, that intervener will be given notice of the intended sideboards of the limitations that would be imposed and an opportunity to be heard, an opportunity to come before the commission and argue against any sort of limitations on their authority to participate. That notice and an opportunity to be heard, we believe, staff believes, improves the due process afforded by this rule and ultimately leads to a better all-around rule. I note, though, again, as was the case in the last rule proposal, this particular section of the rule has rarely been used by the commission in its existing procedures, and I anticipate would be very rarely used by the commission going forward. This is only to be used, in my mind, when necessary to stop the sort of bad actor from bogging down a docket and preventing the commission from carrying out its statutorily mandated duties. So with that, Mr. President, I'd be happy to answer any questions you may have. I suppose I should give formally the staff recommendation first before I hand it over. Staff's recommendation is to authorize staff to send to the Secretary of State both the notice of decision and the notice of proposed rulemaking on a new intervention rule. We would also request authority from the commission to make non-substantive edits that may be required by the Secretary of State for publication in the Administrative Register. Thank you very much.
All right, before we go to motion, Mr. Hamilton, just as a best practice, do you recommend that we take up the notice of agency decision to terminate as a separate matter and a separate motion from the second motioning for a second round of formal rulemaking?
Mr. President, fantastic question. Yes, I do recommend two different motions here, because if the commission decides not to proceed with the notice of decision ending our current rulemaking, it would not make sense to begin a second round of rulemaking that addresses the exact same rule. So I believe a two-step process makes the most sense.
Very good. I agree. All right, I am going to move to issue a notice of agency decision terminating the first round of formal rulemaking on the commission's intervention rules, which were noticed up as MAR 38-2-255. Is there a second?
Second the motion, Mr. President.
Vice President has seconded. Discussion. Colleagues, I think Mr. Hamilton has done a yeoman's job of explaining the reasons why we should vote in favor of my motion. As Mr. Hamilton noted, we did receive considerable feedback, and I would call it pushback on paragraph 8 of our currently noticed rule. There was some concern that specificity was needed in situations where the commission might exercise authority to limit participation in commission proceedings. We heard that from both the interim committee, ETIC, and we also heard it during our public hearing held on that rulemaking. And so I think it advisable that we go ahead and terminate that rulemaking.
Mr. President.
O'Donnell.
Yeah, I also wanted to weigh in on this a little bit in that it's the same type of judiciousness in this, is that I really appreciate staff's efforts to accommodate the criticisms without capitulating on the main issue. I think that is really, it speaks very, very well for very mature and good public policy and rulemaking. Thank you.
Thank you, Commissioner O'Donnell. Additional discussion? Seeing none. All those in favor of the motion to issue a notice of agency decision terminating the first round of formal rulemaking on the commission's intervention rules signify by saying aye.
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 All those opposed signify by saying no. No opposition. Motion carries unanimously. All right, I will then move to begin the second round of formal rulemaking on the commission's intervention rules, which are now noticed up as MAR 38-2-258. Is there a second?
Second the motion, Mr. President.
Vice President has seconded the motion. Discussion? I'm going to be supporting my own motion for the reasons that were just discussed and the rationale for repealing our previous rulemaking. I believe that the new proposed rule on intervention takes into account the public comment that was made in the previous rulemaking and addresses the concerns. I would note, as Mr. Hamilton pointed out, that this new proposal draws heavily from Oregon's intervention rule. And so there is other state precedent for this draft of the proposed rulemaking. Additional discussion?
President.
Vice President Johnson.
Thank you, Mr. President. Mr. Hamilton, this change in Part 9 where there would be a requirement for notice to be heard, does that apply to motions for late intervention as well, or?
Mr. President, Mr. Vice President, if the commission was contemplating imposing some limitation on a late intervener's participation in the docket, I do believe that the notice and opportunity to be heard would be triggered in that scenario. A good example, though, of recent late intervention was Walmart's intervention in the Northwestern Energy General Rate case. No limitations on Walmart's participation were required in that instance. So, for example, where there is no limitation on a party's opportunity to participate, as was the case in Walmart, there would be no need to have notice and an opportunity to be heard because there would be no limitation imposed, if that makes sense.
But Mr. President, I think that history shows that this commission has been a great defender of transparency and has gone out of its way to make sure that parties have an opportunity to be heard. We have on numerous occasions approved late interveners for that purpose, and it seems to me that we maintain that standard with this rule, while at the same time protecting the commission's jurisdiction to exercise judgment if in fact there is, as Mr. Hamilton says, a bad actor that comes into the picture. So I too will support the motion, Mr. President.
Thank you, Mr. Vice President. Additional discussion? I would just put gloss on what the Vice President was alluding to. I would note that under paragraph 5 of the new proposed rule, that timely motions for intervention will be automatically granted unless someone objects. So participation will generally be automatic, but I would note to the thrust of the Vice President's question, there is process set forth in paragraph 6 of our proposed rule that deals with the notice and opportunity to be heard for those that are filing for late intervention. So there is actual process set forth, which would rebut any assertion that what the commission is doing or a hearing examiner is doing is arbitrary and capricious. So the protections, due process protections, are built into the intervention rule. Additional discussion? Seeing none, all those in favor of the motion to begin a second round of formal rulemaking on the commission's intervention rules, MAR 38-2-258, signify by saying aye.
Aye.
Aye. All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, Mr. Hamilton. That concludes the work session item of our agenda today. I'd note a couple public announcements. One for the public. The PSC office will be closed on Thanksgiving Day, Thursday, November 24th. And then our next commission business meeting will be Tuesday, November 29, 2022 at the regularly appointed time of 9:30 a.m. Seeing no further business to come before the commission, the time is now 10:10 a.m. and I will adjourn this meeting of the Public Service Commission.